Welcome to Mastering Machines, where we discover tomorrow's reality.
Hi everyone, welcome to Mastering Machines. Today we're diving into a massive development in the AI/legal world that could change everything about how these systems are trained. So let's get into it and talk about this very big case. Thomson Reuters, the massive tech and media company that's used for a lot of journalistic sources and people's video stories and articles, just won a huge court battle against an AI startup called Ross Intelligence. And trust me, this isn't just some boring legal drama. This could affect every AI system and how it's trained and how it operates. So this is what went down in the case. Ross Intelligence created an AI system for legal research. So that seemed pretty fair and cool, right? Well, there was just one tiny problem. They trained their AI using content from Westlaw, which is Reuters' legal research service. Specifically, they use these things called head notes, basically summaries of legal decisions that Reuters experts wrote. So now you can start to see where the conflict might arise. Now Ross Intelligence is trying to argue that this was totally fine because they were transforming the content. Like when you take someone's song and turn it into a completely different remix. But the judge, Stefanos Bibas, wasn't buying that explanation. And the judge had an amazing quote where he said, "Hold up, you're just repackaging Westlaw's content and competing directly with them. That's not transformation, that's just copying with the extra steps." And the thing is with this AI case is that there's also 39 other copyright lawsuits against AI companies right now. And we're talking about cases against major AI companies like blue chip companies such as OpenAI, Midjourney, and a couple others. All these companies are basically saying, hey, this is all public content. We can use it to train our AI. And it's quite ironic because DeepSeek did the very same thing to OpenAI probably a couple weeks ago, and they were obviously in a tiffy because they thought that DeepSeek shouldn't have stole or copied their work, which is obviously ironic. But now there's a twist in the Thomson Reuters versus Ross Intelligence case. The judge made a point to distinguish between what Ross was doing and what companies like OpenAI do with generative AI. Ross's AI just searched and retrieved existing content, while generative AI creates new content. A lot of legal experts are split on what this actually means. Some say this is just the beginning of a bigger crackdown on all the AI companies due to, copyright infringement and, all the different, ways they've used existing work. And then others think that it's a narrow ruling that won't affect the other blue chip and bigger players in the AI sector. But here's the bottom line. This case is like the first domino in a much bigger chain of cases. It shows that courts are starting to take these copyright claims seriously, and AI companies might need to rethink how they train their systems right now and also in the future. So what do you think? Should AI companies be allowed to use any public content to train their systems, or should they have to pay for it? Drop your thoughts in the comments below, and don't forget to like and subscribe. And remember, Mastering Machines, discover tomorrow's reality.